We have a question, Mr. Secretary, from Attorney Int'l. Please introduce yourself and the organization you're with.
Good morning, Attorney Palacios. Good morning, Attorney Palacios, and good morning, Attorney Panelo. My name is Emerlyn Hill, and I'm Senior Legal Advisor of the International Commission of Jurists. It's a global organization of judges and lawyers. Our headquarters in Geneva, and I'm based in the Asia Pacific office, which is in Bangkok. And I'm also a UP alumni, member of IBP, still paying my dues. And I closely follow what's happening in the Philippines because I cover Southeast Asia, including the Philippines. There are three things that I would like to raise, and one question, 2 points. Many of the points that you raised, Attorney Panelo, have been responded to already by the International Commission of Jurists in its letter to President Duterte, which I believe was transmitted yesterday, and copies of the letter are available outside, and some of the people in the audience, I believe, have copies of this letter. First, Attorney Palacios correctly pointed out that this is a matter of national importance, and it's the entire country that is affected by this decision. And anyone who knows me can tell you that there's nobody else in this room perhaps that wants to see this administration succeed. I would be one of those people because I want the Philippines to improve, to move on. And I want human rights, rule of law to prevail in the country. So, since this is a decision that affects all of us Filipinos, has there been an extensive consultation among government agencies and even the public on this decision? That's my first question. Second,
maybe we should respond immediately to that so that will not be lost. One, the president is the chief architect of foreign policy. He doesn't have to consult. He was elected to be the leader of this country. And everything that he does would be reflected, a reflection of the sentiments of the Filipino people. And to my mind, there is no need for an extensive discussion on that with respect to the other sectors of society. He has studied that. It's been there. He has been, in fact, threatening to do that, and he has finally did it.
Thank you for responding to that question, Attorney Panelo, because the way the statement was issued and even the notice and how you spoke right now, it actually seems that this is a decision that is very personal to the president and actually has an impact on the entire country. And that is really an area of concern for us because to us, it cannot be the decision of it cannot be the decision of an individual that has an impact on all.
Let me ask you, what is the effect on the withdrawal of this country from the ICC? Give me a bad effect.
Okay. One of the, well, it actually shows that the Philippines is turning its back to international rule of law. So it means that we refuse to be part of the international community. We have actually, you said that the Philippines is one of the very few countries in Asia that is a state party to the ICC. That is true. And that is actually something that we should be proud of because we have joined this community and we are ready to combat impunity through this type of proceedings, through this court.
Are we saying now that the United States and other major countries who have withdrawn and do not want to be members are not respecting the rule of law? Precisely, it's the rule of law that the president is invoking from removing itself from the jurisdiction of the ICC.
Attorney Panelo, one thing I noticed is that we always compare ourselves to the United States. One of the things that I can say, I studied in the United States. I went to law school also in the United States. One of the things that we can say is that the United States is not the best example when it comes to international human rights law or even international law. So as a country that aims to be a responsible citizen or a responsible member of the international community, I am not sure if we should be comparing ourselves to the United States.
But even without the comparison, as I said, what effect? You said that we will come out as a violator of the rule of law, but precisely it's the president invoking the rule of law. You're violating the rule of law in this country. And our country should reign supreme over that Rome Statute, which is not enforceable in the first place. You're putting me within your jurisdiction when you cannot do that.
Well, I think you will find in our letter, number one, let me just point out that it doesn't really adequately explain the statement of the President how the preliminary examination violates rule of law. Number two, the preliminary examination, as you clearly stated, is not an investigation, and it doesn't put the President or any other person under its jurisdiction. It's actually really the very first phase of ascertaining whether it has jurisdiction. That's why we indicated in our letter, the ICJ actually indicated in its letter, that one of the best steps that the Philippines could have taken to thwart ICC jurisdiction is to respond to the prosecutor that it is investigating all these allegations of extrajudicial killings. So instead of running away from the ICC, it should have faced it. That would have thwarted the ICC from acquiring jurisdiction.
Let me tell you something about the ICC's position. It said that the withdrawal will not affect the examination being conducted, which is again in violation of its own statute. It says that it will not be affected if the preliminary investigation or proceedings in reference to the preliminary investigation was already commenced prior to the withdrawal. But there is no preliminary investigation. It's only a preliminary examination.
Yes.
So why should they insist that they will still continue?
Well, the withdrawal only takes effect 1 year after notice to the UN Secretary General. And the acts that are complained of actually were occurred during the time that the Philippines was a state party to the ICC. Therefore, the prosecutor still can conduct a preliminary examination over these acts. That is why that's what they're saying. But it's not. It's not acquiring jurisdiction. It's examining whether there is jurisdiction over the subject matter. It's examining whether there are domestic bodies investigating and effectively prosecuting these alleged crimes.
But in its position, it has already assumed that it has jurisdiction because, according to them, it will not be affected simply because the preliminary examination has started.
The preliminary examination. Can I just
intervene?
clarify, Raj?
Sorry, just to intervene, I think we are both referring to Article 127 of the Rome Statute, and there are second paragraph has 3 parts. It talks about obligations of the state which have vested prior to withdrawal, so these are not discharged by a withdrawing state. Second, it talks about if there is an obligation to cooperate in any pending criminal investigation or proceeding, then the obligation to cooperate will continue despite the withdrawal. The third topic on paragraph 2 is with regard to matters which are already under consideration by the International Criminal Court, and a withdrawal by the state will not prejudice the continued consideration of this pending matter. I think that's Article 127. But let me bring the discussion to the statement by the President that the withdrawal is effective immediately. So Article 127 talks about a 1-year withdrawal period. In contrast, the President said withdrawal is effective immediately. And I think that the reason for the withdrawal was that the treaty itself is not binding on the ground of fraud, right? So fraud...
Not only on the ground of fraud, it is not enforceable in this country.
Yes, yes. It's not enforceable in this country as a matter of Philippine national law, and it is not binding on the Philippines as a matter of international law on the ground of fraud. Now, fraud is a ground for withdrawing from a from a treaty under the Vienna Convention on the Law of Treaties.
Yes.
However, the language of the Vienna Convention of the Law of Treaties, to which the Philippines is a party and binding on the Philippines, talks about fraud in entering into the contract. So I would like to request Secretary Panelo and maybe to build on what Attorney M. Hill has stated on the reason for the Philippines on fraud being the ground for saying that the treaty is not binding on the Philippines. Because the Vienna Convention talks about fraud in entering into the contract. Whereas, based on the statement of the President, he's referring to fraud in the matter of implementation of the contract, where the principle of complementarity was not observed.
Yes.
So, I'm just trying to get clarity from the Secretary on whether that can be a ground.
That's my second point, actually. If you may indulge me, Attorney Panelo and Attorney Palacios. My second point is in relation to fraud. If you look at the point that we made in the letter, we note that in 2017, December, the Philippine government actually made a statement at the UN General Assembly that it has reaffirmed the principles under the Rome Statute. And then the second point is that the Philippines has also actively campaigned for one of its nationals, Raul Pangalangan, to be a judge in the ICC. So if you're talking about fraud, can we not say, if we follow domestic law, can we not say that this has stopped from the Philippines from claiming fraud? Because clearly we understand what being a state party to the ICC means. That's all. Thank you.
Thank you.
You know, fraud can be discovered only after the execution of a contract. Because if you know that there is fraud, then you will never enter into this contract. As I said earlier, when we entered into that treaty, we were made to believe that our Constitution will be recognized. Our laws will be recognized. But it did not precisely. The very basic rule on publication, which makes all laws binding, was not observed. That is precisely, we're saying that we're not bound by this Rome Statute. Because it has not recognized. Even the law on complementarity, they can only assume jurisdiction if the state is unwilling or unable. But this country has shown, our state has shown that the judicial system is functioning. In fact, there was Congress investigating this extrajudicial killing, and a conclusion was made that there is no state-initiated extrajudicial killings. There are pending cases against policemen who are charged to have been abusive of their powers. So we're functioning. So even on that score, there can never be and should have not been a commencement of a preliminary examination. Because the state, our state, is precisely not only willing, but is capable of prosecuting those who are perceived to be committing most serious crimes.
Thank you very much, Secretary Panelo. Do we have other questions from the audience?